given your experience, could you explain how the PDP bill should, in your opinion, going forward, address the topic of encryption, and specifically with regard to intelligence bodies, their access or use of the same, and how essentially what more can be done in terms of ensuring that citizens' rights are protected, especially when it comes to intelligence bodies?
There are two very, very important things which the Joint Parliamentary Committee should look at. One is, of course, the nature of surveillance reform, because everyone is talking about it today. The moment you talk about data privacy, you're talking about the prying eyes of the state. But I always appeal to the people not to have an Orwellian approach to the state interest. My suggestion would be go through for a surveillance reform. Today, what is happening is the same rank of authority, the same rank of officer oversees the justification or gives the consent for snooping, tapping, wiretap, or whatever, right? And another one in the same system oversees it. So that's wrong. I mean, I agree with it. So let the lawmaker decide that should it be a parliamentary oversight. Go ahead with that. If talk to the public. You are doing a lot of hearings. Who would people believe in? Would they believe that the lawmaker should give the oversight? Fine. Do the people feel that it should be a judicial oversight? Go ahead with that. So I think this is the most critical, important thing for the data protection bill, because then it will give the stamp of people's confidence that people are saying, okay, fine, whenever people's data is being sought by the state, it is for a legitimate reason, and we are absolutely sure about that. That's number one. Number two is that to protect the sanctity of the Data Protection Authority, which is being set up, has to be absolutely strong, robust, and consistent in its reach. And that's why two things are important. One is, who's on the selection team of the Data Protection Authority? If it's only babus who select, that's wrong, because babus will select babus. So why not have a judicial member in that? Why not have a technical member in that? Why not have a journalist in that? An IIT professor for that matter. And similarly, in the constitution of the Data Protection Authority team, there should be people from, who really have the expertise, who know about data, who have played around with data, who know about cryptography, so that when the issues come to you, after all, it's a very important thing, you're imposing fines of millions. So when people approach the Data Protection Authority, they should be in a position to judge how it has been done. Is it really a breach? What kind of a breach? What is the kind of compensation which is due? These are very, very important things. And the last point is that the Data Protection Authority, if it doesn't have that requisite status and autonomy, it will not work well. Look at the example of Central Information Commission. I was a Central Information Commissioner, but the time I was there, where the status was equivalent to the Central Election Commission or the Supreme Court judges, that has gone down. Your members are now equivalent to a secretary status. We have to look into the issue very, very in a balanced manner. State needs are very, very important. Nobody can deny that. And so is privacy, which is so what do we do? For the intelligence agencies and the security agencies, there's a huge amount of metadata which has to be interpreted. And therefore, their capability has to be enhanced. How do we enhance it? IIT professors, where the management people, where the tech giants, and where the security agencies, they should participate and come through a solution where, the security agencies get the information which they are desiring. And of course, they will enhance their own capabilities through various other means. I think these are important things which the Joint Parliamentary Committee should look into, especially the surveillance reform and the Constitution of the Data Protection Authority.
We've been talking about or reading about the PDP and data protection for a long time now. And I mean, yes, it's in the committee, it's being discussed, all of that is happening. But realistically, my part A to the question is, when do you think we'll actually see this come to life, number one? And part B would be, what do you think the future of encryption and its connection to the right to privacy especially, what does that look like over the next, let's say, decade or so?
Let's have a look around the world. You know, in Australia, this law was passed where access to, decrypt was given to the security agencies, and there was a storm of protest. And then the amendments were, put in public domain, but they have not really been, enacted. Similarly, in United States, the FBI has pushed for, encryption being allowed in the act before the Senate hearings. And again, that is the view which is sort of percolating all over, but being opposed by the human rights and the privacy supporters. UK is the same thing. Now in India, the Joint Parliamentary Committee is deliberating upon it. And yesterday I was in a seminar where one of the members from the Joint Parliamentary Committee said that, well, yes, it was expected to be enacted in this particular session, but they've had a good amount of hearings. And the people there, they're very committed and they're doing a very, very good job, I must say, listening to various, delegations and all that. So I expect it should be coming very, very soon, either in this session or in the next session. That's number one. Now, the future, how is it going to go? Now, that is something where I can tell you one thing, that the security agency will keep arguing for that elusive balance and hoping against hope that some technology will come which will sort of decrypt in a manner that the system does not get vulnerable. That is one. And the third, the privacy debate, I think privacy versus state debate will continue. That will continue for a while, because somehow even yesterday in a seminar, I got the impression from some of the people that they disbelieve the state. They disbelieve the state. These are basically state governments, and rightfully so. Some of them they said that UAPA is being used indiscriminately in some states. The National Security Act is being used a little discriminately, to which I agree. I mean, some state governments have gone, overboard in instituting such cases. So the debate between privacy and the state will continue for a long time. And transparency, last point. And therefore, in various countries, you put on notice how many takedowns appeals were received by the various agencies. Google is doing, etc., etc. Similarly, the state agency should also do. You ask this very important question: what should they do? So they should say that there were so many requests made for wiretaps. I mean, they don't give the details, but the numbers, so that people have an idea. Okay, these are not in crores, but these are in hundreds. That will give also a measure of confidence. So basically, in a democracy, you have to bring, you have up that level of confidence amongst people. And yes, it's about time that we do it, which will be brought about if a good data protection bill is enacted in the Parliament.